William F. Buckley Jr. offers 20 years of firing line guests from the 60s to the 80s. For $19.95, you can receive this companion book by calling 1-800-872-8188. Credit cards are acceptable. Or send a check to Firing Line, 2700 Cypress Street, Columbia, South Carolina, 29205.
Welcome to Firing Line. I'm Michael Kinsley of the New Republic magazine. In June, the Supreme Court ruled that the constitutional freedom of religion does not give American Indians the right to consume peyote as part of a religious ceremony. You would not think that this decision would alarm America's larger and more conventional denominations, but you would be wrong. The National Council of Churches, the American Jewish Congress, the Baptists, the Evangelicals, the Quakers, and so on, have all raised their voices in a choir of protest. What concerns the religious leaders is not so much the court's decision as the reasoning Justice Scalia used in reaching it. Scalia declared that a generally applicable law or regulation, such as a law against drugs, is not unconstitutional just because it places an incidental burden on religion. The First Amendment is only violated if a law is, quote, specifically directed at a religious act. This would seem to contradict past Supreme Court rulings that the government cannot interfere with the practices of religion unless there is a, quote, compelling state interest, which means a damn good reason. Critics of the court's ruling raise the specter of laws forbidding kosher meat or the use of wine in the Roman Catholic Mass. More generally, this ruling raises once again the question whether we are a secular society that tolerates religion or a society in which religious values in any conflict are paramount. And it has also created a delightful split among conservatives. Some rejoice in Scalia's ruling as another blow against judicial activism and the over-imaginative interpretation of the Bill of Rights. Others fear for their sacraments. Mr. Buckley's guests are one spokesman each for the laws of God and the laws of man. Pastor Richard John Newhouse is a Lutheran clergyman, author of many books, director of the Institute of Religion and Public Life, and, not incidentally, religion editor of the National Review. Charles Freed is Carter Professor of General Jurisprudence at Harvard Law School. He served as Solicitor General of the United States during the second term of President Reagan, and he's got a book to plug, which is called Order and Law, Arguing the Revolution. Mr. Buckley, if the court had ruled the other way, what would there be to stop me from founding a religion based on, say, the worship of William F. Buckley and the consumption of vast amounts of marijuana?
My failure to have died and ascended into heaven on the third day. A religion based around me would not be very convincing, but I see the point that you're groping for, which is that if one takes the notion that the free exercise of religion permits a religion to write laws which contradict the standards of society, you could theoretically have such situations develop among the Mormons in the late part of the 19th century, in which we either were or we were not going to defend monogamy. Now, how do you handle that, by the way, Pastor Newhouse? How did the Supreme Court vote correctly on the Mormon decisions?
Well, Justice Scalia raised in his opinion for the majority precisely the kind of question that Mr. Kinsley raised. And I think Justice Sandra Day O'Connor quite rightly criticized Scalia for this, pointing out that this was a parade of horribles that he was throwing out there, which was really an argument against the free exercise of religion itself. And he was writing as though we did not have 200 years' experience with the First Amendment. The critical thing, it seems to me, in the so-called peyote ruling or Oregon versus Smith, the critical thing is precisely as the churches are claiming and the synagogues are claiming, is with the reasoning, the philosophy, if you will. The founding vision of the First Amendment religion clause, with its two parts, no establishment and free exercise, was, as Michael McConnell in the recent Harvard Law Review argues, rightly, I think, the founders' intention to say that the state is limited by a higher sovereignty, and that religion in society
The
is
Madisonian
the carrier of that witness. Madison, of course, would be the chief architect and articulator of that way of thinking of our Constitution.
Have you got a historical or a scholarly problem with that summary?
I think
Professor
I
Frieden?
do. It seems to me that the religion clauses, of course, did indicate a very important role for religion. But it's a very common sense one. On one hand, no religious persecution and leave religious people alone and don't interfere with them. But that doesn't mean that they are free to interfere with the rights of other people. That's the place where this gets to be difficult. So that you have the case which I think illustrates this so nicely, and these cases are coming up a lot in terms of Indian religions, which are rather unfamiliar with us and have all kinds of tenets which many of us have difficulty grasping. That was a case where the Forest Service had a road. It was an unpaved road between two towns, and it was on Forest Service land, didn't belong to the Indians, wasn't an Indian reservation, nothing of the sort. And they wanted to pave the road so the people in those two towns could communicate easily. And the Indians said, you mustn't do that because that land is sacred to us. Now, I think there's something a little bit disturbing about people quite sincerely being able to say, no, you mustn't pave a road on government land which doesn't belong to the Indians,
But
belongs
Mr. Fried,
to because it will be disturbing to us and thereby upset the ability of the people living in those two towns to go from one to the other.
But doesn't that, along with the Smith case on peyote, precisely indicate our experience with being able to demonstrate a compelling governmental interest that in the case of the road and in the case of peyote, the court ruled overrides the religious claim? The critical thing about the Smith decision is that long, long history where someone has to come with a claim and say, I got a free exercise of religion claim here. And then we have decision after decision after decision in which the court either says that there is a compelling governmental interest that overrides that claim, or there is not. Just as free speech is not an absolute right, or
Okay.
free association is not an absolute right. So free
Let me explain to the viewer who is less familiar than you all are with the background of the case. There are 23 states in the Union in which you are permitted to use peyote. You smoke peyote or do you drink it?
You ingest
You
it,
eat it.
yes.
And the federal government has no law against eating it. Therefore, it was the implied, and I suppose explicit contention of the petitioners that you couldn't argue a compelling national interest given the fact that 23 states went ahead of their own free political will, and therefore Mr. Scalia was required to use other arguments than the traditional ones. And this is really what upsets you.
Right.
And what I think is, I'm sure what was moving Justice Scalia is that you need to have a constitutional standard which doesn't mean that every one of these cases end up in the Supreme Court and the only person who knows whether you can do it or not is Justice Brennan. He's just retired. That's the trouble. You need something which tells you with a good bit more definiteness than that. Why is an interest compelling? This was, after all, a 6-3 decision, and 3 dissenters thought it wasn't compelling. You have there's this marvelous case, again, an Indian case, where a father said that it would rob his daughter of her soul if she had a Social Security number which he communicated to others. However, he did want to collect AFDC for this child. And the question is, does the government have a compelling state interest to enforce its system of Social Security numbers so that, for instance, they're not collecting AFDC 3 or 4 times? Who knows?
You're a professor of law. Explain to me what compelling means.
Very
Does it mean plausible?
No, it does not mean plausible. It means something of very great urgency. And also, it's not just compelling. It's a very urgent interest and one which cannot be served in any other way. So in the case of the Social Security number, you couldn't find any other way to make sure that this girl wasn't getting 2 AFDC payments. Now, it's interesting. The Supreme Court said that the government was entitled to insist on the use of that. Now, I don't understand what the rule is. I don't understand why that was compelling, and somebody would say that peyote is not.
It
And
seems
that's
very
also-
arbitrary, yes.
Well,
Would it be
that's just the
would it
point,
be a
sure.
compelling interest of the state to insist on universal education?
Oh, yes, I think
Okay,
it's an
then how did they handle the Amish protest?
The Yoder case.
I think that's a very important thing which Scalia dealt with, because it's not just the Amish, but also educating people in Roman Catholic schools, which goes back Pierce Against Society of Sisters back in the 20s. And what's happening there is we have not just the free exercise clause, but we have a whole additional constitutional tradition which says that parents have a very important interest in the education of their children. And so those things come together and overcome the state's interest. For instance, there was a similar case which said that you have the right to educate your children in the German language. No religion aspect to that at all. And the Supreme Court agreed with that back in the 20s. So I think there is a little bit more than just the free exercise. The trouble with the free exercise claim is that in all sincerity, almost any practice, almost any form of conduct can be urged as being important religiously, and nobody can inquire into that any further. And that means that the state is simply a hostage to almost anything that might come
But
along.
in fact, that's not the case. That is not what has happened. What has happened is, and that's precisely why all these cases come to the courts, not only to the Supreme Court, but other courts on their way up to the Supreme Court, is precisely because the state does inquire, precisely because charges are brought. The Yoder case, which is a case of the Amish parents in Wisconsin, is a classic instance. I would consider it the high watermark of pre-exercise jurisprudence.
I think it's a wonderful decision.
I think it's a great
by the way.
decision, all right? The state of Wisconsin had a rule that parents had to keep their children in school until age 16.
Yeah.
And this was against the beliefs of the Amish. And they said that there is no evidence whatsoever that keeping our children in the public school till age 16 is going to make them better citizens or more productive people or anything else. On the contrary, the Amish practice of just giving elementary education and then integrating them into the life of their community demonstrated that for the whole society this was working marvelously well. Therefore, the Supreme Court, rightly, and I'm glad to see we agree on that, said that clearly there's no compelling state interest that would override the religious convictions of these parents. The interesting thing, however, Professor Freed, is that you and Justice Scalia in the Smith decision both appeal to parental rights, which are not to be found in the Constitution as such, certainly not explicitly. Whereas for someone who's a conservative, which Justice Scalia presumably is, and I think you are generally considered, and if it is true that conservative jurisprudence is very respectful of the original understanding of the text, the amazing thing about the Smith decision is that there's no argument whatsoever with regard to original understanding or of the text itself, and a great deal of weight, even the weight of the Yoder case, is placed upon parental rights, which is a concept, a very good concept, but a concept totally premised upon precedent, not upon the text of
There
the
are all
Constitution.
kinds of conservatives.
It's a strange conservatism indeed.
I'm a Harlan conservative, and actually when I clerked for him, we wrote the original contraception case, the dissent in Povey Ullman, which relied on parental rights and marital rights, and the integrity of the family, and the notion of privacy. So I think conservatives can understand the notion of privacy and the importance of the family and the importance of the family thumbing its nose in a way at the authority of the state.
But can conservatism void the text of the Constitution? In this case,
I hope
the
not
religion clause
void
of
it.
the
I
First
hope not
Amendment.
void it. I don't think
Isn't
it
that
is.
what Smith does?
I don't think it voids it, because the original understanding was surely a good bit less demanding than that. The original understanding was, first, no religious persecution. For instance, no testos. And we had a case as late as the 60s, 1960s, where it said that if you were Torcaso against Watkins, if you were a member of the clergy, you could not serve in the legislature. That was struck down, and quite properly, an absolutely classic example of what the Free Exercise Clause was intended to cover. And I'm sure that Madison would have recognized religious disabilities as a perfect example of free exercise. But it's in the realm of belief and in the realm of profession. When you get to the realm of conduct, it gets very difficult because conduct impinges on others.
But if you agree with Yoder had to do with conduct. Namely, the state was challenging the conduct of these parents with regard to the raising of their children.
Of keeping them back from school.
Yes. And Yoder very explicitly, and William Bentley Ball, who argued this decision, is emphatic in disagreeing with Scalia. Scalia says that Yoder was decided on a hybrid basis that involved not simply free exercise of religion, but also parental rights, etc. To which Bill Ball says, absolute balderdash, not the term he used. But because he argued this, and he said it was totally argued on and decided on the basis of the free exercise of religion. And Yoder today, if Smith holds, if the Scalia decision holds, Yoder would go the other way.
Well,
It couldn't be
I'm
upheld
not sure,
under free
because
exercise.
when you're talking about education, you can call that conduct, and I suppose it is conduct, but it's conduct in the realm of ideas, in the realm of communication of ideas, in the realm of profession of beliefs. And that, I think, is much closer to the use of drugs.
But how would that cover the consecrated wine or the or the kosher pork, which were mentioned by these groups that Mr. Kingsley talked about?
Well, those really are very troublesome. I must admit that the argumentation in Justice Scalia's opinion would clearly extend to consecrated wine, and one would hope that Congress would make, as in fact it did during Prohibition, appropriate accommodations.
They were immune from the Volstead Act?
That's right. The consecrated wine.
What about affirmative action?
Oh, I think there you again are in this hybrid situation, because affirmative action, say, for instance, do you have to have homosexual priests, for instance? That's an example.
Or ordained women.
Or ordained women. Yeah. It seems to me, under those circumstances, what you're talking about is not just conduct. We're talking about association and the who can associate, who you can say is allowed to speak for us. I think that's a very
Well, but who's going to create
part
the
of it.
immunities for the churches?
But I think that's covered by the free exercise. I would cover the...
Would you be consistent with Scalia, though, with Scalia?
Well, if not, then he would be wrong. Because I think the element of expression, of association, and of religious profession is very strong in the affirmative action.
But that hasn't hurt affirmative action in secular mattars.
No, it hasn't, although I think perhaps it ought to a little bit more than it has.
Well, so suppose Harvard would say, look, as far as we're concerned, we want just men students in law school. And we plead this associational liberty. Would you have a chance of surviving?
No, that specific argument has been rejected. But in a religious context, it has been given, in the famous Bob Jones case, the court indicated that they would listen to that. That they would listen to it in the religious context. Because when you're talking about religious association, the formation of your congregation, who is in it and how it is organized.
But it's not clear now that the court would listen to it. In fact, Scalia very clearly says that for these circumstances in which especially minority practices are involved, that this will be up to the legislature to make exceptions. And I think one of the most callous statements in contemporary court language, or in the recent history of court language, he says, we recognize that this will create a certain disability for minorities in our society, namely those that
minority religions.
Yeah, that aren't able to muster a majority in the legislature to get an exemption, to get an immunity. This is an astonishing, at the philosophical level,
he was making
of a free
bit of a meal
society.
of it, wasn't he? I mean, it's...
what a remarkable statement. What are rights for if they are not there to be protected against majority?
I'm with you there.
You don't say you have a right if you can get a majority to agree with you that you have the right.
But
that's no right at all.
But I do think that what we're talking about is the associational aspect, the profession and ideas, there we are at the heart of the free exercise clause. The free exercise clause meant no religious persecution, freedom of religious profession. And if a religion cannot choose its spokesman or spokeswomen as it wants, then I think a very important aspect of profession is involved. On the other hand, when you're talking about actions which impinge on outsiders, persons who are not part of the congregation or not part of the faith, there I think Scalia has a point. Now, you know, all people don't take the problem of drugs with equal seriousness. But if you grant the premise that allowing the use of drugs anywhere has this terrible spillover effect on innocent third parties, then
As
it's a
in
little
Oregon,
bit
they presumably think it does.
well, that's right. Then it's like air pollution, that you shouldn't be able, as a part of a ritual, to burn tires in a residential neighborhood. It's a little bit like that.
Let me ask Pastor Newhouse this question. Are you engaged in your protest today in an intellectual and scholarly reproach? Or do you really fear that the obiter dictum of Scalia might actually lead to the kind of harassment we've listed against the Jews, or against the Catholics, or the...
Oh, no, I mean, the groups that are well established and that have constituencies and that are able to articulate with political persuasiveness in the public arena, they don't have to worry, because they will be able to muster in this kind of society, which is pervasively religious and sympathetic to religion, they will be able to muster the exemptions that are necessary. But at the margins, which is where I think we have to worry, all right, in principle, the Smith decision undermined the protections that were there. But I would say that I am less alarmed about a parade of horribles, if you would, of the terrible things that are going to happen as a consequence of this, than I am, and I think other people involved in the churches and synagogues are, about what this says about the constitutional order, and what this says about whether, in fact, we believe that rights are established by nature and nature's God, as the Declaration says, whether we believe in the Pledge of Allegiance that this is a nation under God, or is this all just pious fluff?
How
Now,
did
I
the
think most
ACLU get
Americans
involved
don't
in
think
this
it's
protest?
pious fluff, huh?
How did the ACLU get involved in this protest?
Well, the coalition that has been put together in terms of first petitioning the court to reconsider, and that was turned down, and now moving to Congress an effort to remedy Smith legislatively, is a most astonishing coalition indeed. I mean, it ranges all across the board from the fundamentalist
Because they've never been much worried about the free exercise.
I know, but they're worried.
have they?
Pastor Newhouse really makes a very important point there. You know, you've got a lot of countries, and we're not one of them, that proclaim freedom of religion. For instance, revolutionary France proclaimed it. Soviet Union proclaimed it. And what they meant by freedom of religion is you're free to be religious so long as you are intensely private about it. And
don't go to church.
And don't go to church, that's right. And obviously, our traditions of religious freedom are a good bit more capacious than that, and much more vibrant. And if I thought that Scalia's decision were taking us to a kind of French revolutionary notion, I would be as horrified as you are. But I don't see it that way.
But you're making a sociological point, not an intellectual point.
Well, it's the two go together, because I think that if you focus on profession, association, and religious, well, profession I think is a good way of putting it, preaching and profession and getting together, and not situations where you are impinging on the rights of outsiders, then I think you're all right, and I think you're still very far from, you know, the Soviet or the French Revolutionary model.
Excuse me, Mr. Buckley, I didn't detect an answer from Pastor Newhouse to your question about Mormons and monogamy. For that matter, I wouldn't mind hearing an answer from you. Does the free exercise clause, or does it not, permit Mormons to practice polygamy as part of their religion? And if it does not, how do you get your right to your sacramental wine? Where do you draw the line, in other words?
Well, I draw a line by saying, quo licet Jovi, non licet bovi. You don't appeal to drove in the same language in which you appeal to cows. And the difference between that consumption of wine, as is necessary to consummate the Catholic communion, cannot compare with the kind of social disruption that a violation of monogamy does cause. And under the circumstances, the word compelling is, I think, plausibly introduced.
So you prefer the previous standard, the pre-Scalia standard, that there has to be a compelling state interest in order to override the demands of a religion?
Yes, it seems to me...
You want to leave it in Justice Brennan's hands.
He ignored compelling, the word compelling, it seems to me.
He didn't ignore it.
Unless
He said
23
it was
states
wrong.
always ignore, or simultaneously ignoring it.
Well, states are entitled to reach different decisions about what's compelling. That's the whole point of federalism.
Yes, but whether in the whether in context the Supreme Court should violate a religious right in order to protect what might be thought of as an eccentricity of the state is the kind of thing we do talk about, isn't it?
Mm-hmm. Indeed. Yeah, I think, you know, the case of Mormons and polygamy, there are a good many people, I'm sure you'd agree with me, Professor Freed, in the legal profession today, who would raise a very real question as to whether that was decided properly back in 1869, am I right?
Yes, they might raise a question, but I would think even before Scalia's decision, it would have been decided.
I mean, if
Oh,
polygamy...
I think so, yes, but it clearly was an effort, it was an instance, as Mr. Buckley said, of pitting a claim to religious freedom against
But I
a
think
compelling...
if polygamy, if the decision about how many wives to have isn't a family decision, what is?
Thank you, Pastor Newhouse. Thank you, Mr. Professor Freed. Thank you, Michael Kinsley, ladies and gentlemen.
Funding for Firing Line was made possible by a major grant from the John M. Olin Foundation, Incorporated. Additional support